How old were you at the time you did this to this child? She was 8, and how old were you?
40, 39.
Okay. She was 8 years old. The DA goes on to say is that at this point now, you are only 56 years old and will certainly reoffend.
No, ma'am.
Well, I can tell you this, statistics show you will, because nobody can do that in the beginning unless they like little children.
And that, ladies and gentlemen, Mandalorians, that is Miss Stapleton, Louisiana's designated victims advocate on the Louisiana Board of Paroles. And how refreshing is it to hear it stated as fact that no programs can make you a low risk to reoffend when you do something like this to little ones. Now, we have the appeal, so we will go through the facts of what he did at the end. Now, with that, let's jump in.
Take it off of mute there, and there we go. Looks like a pilot now.
Yes. Can you hear me?
I can indeed.
This is Captain McMurray.
Okay, Captain, thank you for hosting us today. And in just a minute, I'm going to ask you what kind of fella Greg Freeman has been since you've known him and how long you've known him. But right now, let's do the interview with Mr. Freeman. Mr. Freeman, we want to start this by you telling us exactly why you're there, what you were charged with, what you did, how you feel about what you did, what you've done since you've been incarcerated, and why you deserve to be paroled early. Now's your chance that you've been waiting for quite some time to take. So tell us about that.
Yes, sir. Well, I've been down since 2008. I've taken all the classes I can take. I worked the jobs whenever I've been able to get a job. You know, I haven't been in any trouble.
Okay. What did you do?
Sir,
What did you do to get yourself in jail?
I committed a sex offense.
That's pretty open-ended. Give us a little more detail, not explicit detail, but against who and why? Tell us about it.
Well, I don't know why.
Don't know why you did what you did. So what did you did? What did you do?
The charge is molestation of a juvenile.
Okay, so far, what we look for is people that are accountable for what they did. You denied, or not denied, but you hadn't told us that to start with, and you're questioning all I'm hearing is what you were charged with. What did you do to get you there?
I mean, I don't understand. I mean,
Okay, I'm gonna turn it over to Miss Stapleton. Maybe let me ask the captain. Captain, what kind of fellas has Mr. Freeman been?
he wants to know what he wants to talk to you.
Yes, sir.
What kind of fella has he been since he's been there?
Sir, I really can't tell you. I've met him just today.
Okay. Well, what kind of fella has he been today?
He's just been sitting here waiting to log on.
Okay. All right. We're gonna turn this thing over to Miss Stapleton to ask any questions, and maybe she'll get into it a little bit further. I'm not satisfied yet, but I think Miss Stapleton will get us where we're going.
Okay, so I'm going to pick up where Mr. Prater left off. You were charged with molestation of a juvenile,
Yes,
which
ma'am.
was a plea bargain. So it was pled down from what did you actually do to this child who was 8 years old? What did you do to her that you accepted a plea bargain?
Molested her.
What would you say, aggravated rape?
No, ma'am.
Well, that's what you were charged with,
Yes, ma'am.
but you wouldn't say that. You'd use the word molested,
Yes, ma'am.
but you raped her.
No, ma'am.
They did an examination on her.
Ma'am.
I'm going to read what the DA had to say, okay? The defendant was originally charged with aggravated rape. He pled to the lesser charge in part due to the victim's young age of 8, thereby receiving a fraction of what he could have received. He should be required to serve every single day of his sentence. What he did is horrific, and it occurred numerous times. She is scarred for life. How old were you at the time you did this to this child? She was 8, and how old were you?
40, 39.
Okay. She was 8 years old. The DA goes on to say is that at this point now, you are only 56 years old and will certainly reoffend.
No, ma'am.
Well, I can tell you this, statistics show you will, because nobody can do that in the beginning unless they like little children. They can't even go there. It doesn't matter how drunk they are or how high on drugs they are, they can't do that. So I see where you completed the Steve Hoyle program, all 4 phases. Is that correct?
Yes, ma'am.
Okay. And any other programs that you completed?
No, ma'am. That's all I've been offered. I've asked to get another program, but I haven't been able to.
So what do you think is the long lasting effect for this child?
I'm sure it will have a mental effect for a long time.
Yeah. Like we've seen here, we've seen we've seen children grow up and be in their 20s and be on here. And I've had them in my office and they cry like a baby because it was their daddy. Somebody had trusted them. And that's a funny thing about this sexual offenders. We teach children stranger danger, but when it comes to this particular crime, it's going to be somebody they love and trust.
Yes, ma'am.
So a stranger, maybe they can think, I'll never see that person again. They've been put away. But somebody they love and trust, how do they love and trust again after something like that? So you have opposition from the DA, which is adamant. You've got the judge's opposition and you've got the attorney general's opposition. I also see where you've got an alcohol problem. So
Yes,
when you had numerous DWIs and hit and runs.
Yes, ma'am.
You didn't think that led to your ability to molest your child, did you? The alcohol?
Quite possibly, yes, ma'am.
Okay. Well, I'm going to suggest no, but I know that it's a common excuse. So you do need help with alcoholism too. Did they cover that in Steve Hoyle?
No, ma'am.
Is AA something you would attend where you're at?
Yes, ma'am. I would have to.
Okay. Have you been doing it? And is it offered?
No, ma'am.
It's not offered.
I've asked to get in.
All right. Do we need to try to move you to another facility so that you can get help for alcoholism?
I believe I might be able to get it. Y'all still offer substance abuse here, Captain?
Not sure.
What did he say?
He said he wasn't sure if they still offered substance abuse here.
Well, I'll put it in my comments that you do need to be transferred to a facility if necessary where substance abuse is, is offered. So I don't have any further questions or
Okay,
statements.
Mr. Tillis? I don't have any questions. Let's vote.
Mhm. Okay, today I vote to deny you based upon the heinous nature of the crime. You do need more classes because you do have a substance abuse problem. And your full-term date is in 2027. So get all the help you can get.
Mr. Tillis?
Mr. Freeman, it seems like you're trying to better yourself, and I hope you do, but at this time, I hope you take some more classes, but my vote's gonna be to deny.
Yes.
Okay, likewise, because of the nature of the crime, and I think you need to serve the rest of your sentence. My vote also is to deny. Keep doing what you're doing. The time is 11:12, as of today, at 11:12. Parole's been denied. Thank
All
you.
right, and I'm going to go over the docs of this case. I just want to share with you, though, out of today's docket, because we're going to see a lot of parole hearings from this day, from this very day, which was July 24th, 2025. As you can see in the spreadsheet that Lady Holly put together for us, all the red ones are those who are in there for offenses against little ones, as you can see. And then we'll go over the research. So it's a rough day. Now, let's go look at the facts of the case just so you can see with your own eyes. And all I gotta say is thank goodness for Miss Stapleton, the victim's advocate, because had this been in another state, who really knows? They probably would have said in the state of Connecticut, well, we would like to have him out there with supervision, so let's go parole him. That's something that we would have seen, and it's really remarkable. It really is. But it's something new that I've noticed, and maybe I should have been calling it out sooner because I'm not quite sure. I can't put my finger on it when it started. But Louisiana does not mention the static 9-9 risk assessment anymore. Isn't that interesting? Like they used to. They used to read it out just like every other state, but they've stopped. And again, I can't quite put my finger on the date. But isn't that a beautiful thing? They know it's complete BS. They don't buy it anymore. They don't drink the Kool-Aid. And we've been yelling about the static 9-9 since we've ever heard about it. So I think we are making progress. It's pretty cool. Now let's look at the doc, right? The two-faced DAs and judges that gave this deal. And yet here they stand yelling in their written letters, because they don't take time to actually show up, that the deal sucks, more or less. And it's like, you're the ones that agreed to the deal. You're the ones that, no matter what, anyways, this roach will be out in the streets in 2 years. You're the ones that made that happen. After being arrested for aggravated hard R word, Gregory Freeman was charged with bail. I try not to say it as much as possible because YouTube is just weird like that, okay? And his 9-year-old stepdaughter, violation of blah, blah, blah. He pled guilty as charged and was sentenced to 19 years at hard labor with the order of no contact with the victim's family. He now appeals. Freeman's Boykins hearing was not transcribed, and the district court fully developed the underlying facts. The sentencing in June 2007, Freeman's wife approached the bathroom of their trailer. She could see him standing in the doorway with his pants pulled down, doing this in front of her 9-year-old daughter. After being discovered, Freeman left the trailer. Ms. Freeman called the Ouachita Parish Sheriff's Office, and good for her, because how many times have we heard stories where they turn a blind eye, insanely enough? The girl told a sheriff's corporal that Freeman had been moving her head back and forth, putting his thing in her mouth and rubbing her down there, referring to her private parts. Miss Freeman took her 3 children and moved to North Carolina. There, Child Protective Services interviewed the children. The younger girl and boy reported no abuse, but the 9-year-old described repeated events of misconduct. These included Freeman coming into her bedroom and putting his in her mouth, sticking his in her private ear, and holding the door shut while doing these things. and threatening her if she told her mother. The child's description of adult male anatomy was graphic, and a doctor confirmed persistent anal dilation, consistent with entry. Freeman admitted that the incident occurred at most possibly 3 times, but denied penetrating the victim, holding the door shut, or threatening any of the kids. Right, of course, that he of course didn't do. As noted, Freeman was arrested for aggravated but charged with molestation of a juvenile over whom the offender had control or supervision. He pled guilty as charged and received 19 years of hard labor with order of no contact with the family or the victims. The motion to reconsider was denied. He now appeals. And they go over, let's see. I don't think there's anything. Oh, look at this. They go into the PSI where they talk about his DWI. So the district court held a long sentencing hearing in which it was related to details of the PSI, heard testimony from Freeman's mother, and discussed the sentencing factors. The court noted that Freeman had worked as a welder and provided good financial support for his family, also had no prior felonies, but his 4 prior misdemeanors, including 2 DWIs, undercut the claim of relative crime-free past. Couldn't you still get him in as an habitual offender with 4 DWIs? I don't know. As an aggravating factor is the court, I mean, at least habitual offender DUI, because I get that it's not felonies, but I don't know. Maybe it would have been, you couldn't retroactively do it. As aggravating factors, the court found serious emotional damage to the victim and no justification for Freeman's conduct. Most importantly, the court noted that enormous benefit occurring from the plea bargain, which reduced his exposure from mandatory life to a maximum of 20 years. And there you have it. I mean, look, the parole board handled it great. It doesn't surprise, I think, anyone who's accustomed to this channel to see how somebody would act. But it is crazy to see that 19 or 17 years later, and he can't even fake empathy. He can't even fake a story. He can't even, I mean, there's just nothing. He's been doing nothing in this jail. It kind of summed it up with his jailer over there, Bubba, who was like, I don't know. It's like, this was like a classic Louisiana, and this isn't true about Louisiana as a whole, but if someone wants to paint the picture of what Louisiana, will look like in Bumbleville or whatever, this sadly would be a portrait that would paint that stereotype. It was just, but we'll jump into another hearing. Let's go through Lady Holly's interesting facts of the day on this case, because that's always fun to do. And also, and on this point, actions speak louder than words, meaning what you do is more important than what you say. Example, don't just tell me you're going to change, do it. Actions speak louder than words. A proverb is the theme. So, interesting. I don't know how relevant this is, but I did like that Miss Stapleton brought up, they teach us stranger danger. And that's really not where most of the offenses come from. They come from those who seek out women with children, marry them with one goal in mind. And that is something that should be taught to really single women with children. And then the children themselves. All right, let's jump into another hearing.
Good morning, Mr. Ferguson. Can you see us? You're on mute, please. Yeah.
Okay, is that better?
That's better. And your name is James Ferguson, correct?
Yes, sir.
What's your DOC number?
536195.
Okay, and you're at Wynn Parish Detention Center, correct?
Yes, sir.
Okay, would the staff at Wynn introduce yourselves, please?
Tessa Musgrove.
Okay, thank you. Thank you for hosting us. We appreciate that. We'll call on you in just a minute. My name is Steve Prater. To my left is Chuck Tillis. To my right is Carolyn Stapleton. We're on the Committee on Parole. We'll be hearing your case this morning. The time is 10:10. And the date is July 24th, 2025. The way that we'll handle this, Mr. Ferguson, there's nobody going to be speaking on your behalf and nobody speaking in opposition against you. But we'll ask you first off, what did you do to get you there? Why are you in jail? What have you learned since you've been there? And why do you think you'd be a good bet for us to vote to parole you today? So go ahead and take it away. It's your shot.
Okay, that's well, obviously I'm here for having an inappropriate relationship with an underage girl, and big mistake, poor choice. And I mean, I say poor choice. It's just, there's really no excuses and I'm not going to try and make any excuses or anything like that. But, I've had 18 years to, sit and think about all of that. And, do I regret doing it? Yes, because the lasting effects of what happens, it wasn't just that it affected me, that, I was incarcerated and have been down for 18 years, is that the effects that it had on her brother, herself, her mother, her, all of her family, the effects that it had on my children. They've grown up. My daughter is here with me today, and I have a wonderful family that has been very close to me and very supportive through this entire time. But they've grown up, seeing daddy on the weekends, and there was, times where, you want to hurry up and get home because there's first dates and graduations, birthday parties, and, those are all gone. Marriages already happened, birth of grandchildren, that's already happened. So, I mean, there's just a lot of things that daddies are supposed to be there for. And I, out of my own choice, took myself out of that equation through selfishness and, everything else. But, you don't think about the domino effect of things when you are just, I guess, just doing things that you do. And, and a lot of people, I'm a better person for it. And I mean, there's a lot of things that you have time to think about. And I really believe that I'm a better person now by far than I was, even well before this all happened. You realize the things that are small that you took for granted, and you think about the way other people feel about things before you act. And, if I were to get paroled, I guess I don't know why I would be a good candidate for parole. Is, it's just, I don't know. That's a tough question too, because there's a lot of reasons that you can come up with, but the main one is just that, I feel that I'm a much better person, and I'm more attentive to wanting to be in my children's life more. And, you can't make up for things that you've done. And I don't know. I'm generally a big talker, but I'm kind of at a loss for things to say. It's.
Well, we appreciate it. I think you summed it up pretty well. Your case has been, well, let's hear from the officials at Wynn Parish. How long have you been there?
I've been here for almost a year now.
Okay, and how long has Mr. Ferguson been here?
2 years.
2 years.
Okay, and what's his reputation around the facility?
He's good. He's one of our right-hand guys. He takes care of a lot of business for us. He's a floor monitor. And he's got a real good rapport with the staff and everybody else.
Okay, thank you for that. Mr. Tillis, this case has been assigned to you, so would you take it from here and ask any questions that you have?
How are you doing, Mr. Ferguson?
Oh, I'm nervous.
And you've served 18 years of a 20-year sentence
That is correct.
for molestation. And you've had some sexual classes
Yes, sir. They offer the Madison program. I've taken it. The fifth level of it, it's not a requirement, but I took it in. That's the facilitator level, but I've taken that. We emailed the copies of the certificates on the 11th of this month.
I have. What did you learn out of some of those classes?
Well, it's basically what they tell you in the classes is, they give you scenarios and ask you, what risk factor you're at. And being completely honest, there's a lot of the stuff in there that is, people feel doesn't apply to them, but you take it in. But I guess, out of all of it, if you take aside, I guess, some of the creepy scenarios they put in there, it's just trying to basically give forethought to any decisions that you make. Actually try to, I guess, curb some of those thoughts.
If you were released, where would you live?
In Bienville Parish on Lake Bisno and Ringgold. It's kind of out in the country. It's right on the lake.
Okay, and you still have contact with your family?
Yes, sir. Regularly. My daughter a couple of times a week, my son about once a month, and my mother is every Sunday.
For Sunday. I see. And you have 2 years left.
Yes, sir.
I have no more questions.
Okay, Ms. Stephenson?
Yeah, you said that you had an inappropriate relationship with a young girl. What was the inappropriate relationship and how old was the child?
She was 15.
Okay.
And
How old were you?
I was 30.
Okay.
Well, basically we were, at the time I was dating her mother, and we, like I said, not making excuses. We were having issues, and we had grown pretty close, and we basically, we basically started more of a fling that I can't really call it a relationship. We started a fling, and it just was not.
Well, the fling, what was the fling? Did you have sex with the child?
Yes, ma'am.
I wanted to know. Okay, so you did have sex with the child. And how long did that last?
Oh, about a month and a half.
Okay, all right. Okay, so you do have extreme opposition with the DA, the sheriff, the AG. You're gonna be getting out in a couple of years. You've had your classes. You should have no contact with this individual. I hope you know that.
Yes, ma'am.
Was there a situation where somebody called her mother and everything?
They got into contact with my daughter in 2019. My daughter and the mother had supper together, and they did a lot of talking. She gave her number to my daughter to give to me. I've talked to her mother. Wasn't long after that, the victim got in touch with my daughter, and she wanted me. So we actually, at that time in 2020, Kayla,
Let him finish. Go ahead.
Yeah, go ahead.
in 2020, the victim actually was propositioned that if it helped with my parole, she wanted to actually get married. And that ended up kind of puttering out because there was a long time there. I haven't, like I said, I haven't spoken. I've been here right at 2 years. I haven't had contact with her. We have an email, like a texting tablet system over at the other facility I was at. And we actually stayed in fairly regular contact, but since I've come over here, we haven't really been in contact with each other or anything. But that actually started in about 2019, where we started. We had a chance to actually talk about what happened. Talked about what happened with the mother, and honestly, after that, there was a lot of. It was a lot of crying, and we came out of it. I with a different mindset, and you know, a lot of feelings got lifted.
When you say she wanted to get married, who are you referring to?
The victim,
The victim wanted to marry who?
me.
Okay, all right.
Okay, any other questions? Okay, let me ask you, what was the contributing to the delinquency of juvenile arrest in 2005?
That was I was in my vehicle. My son was with me. Me and my ex-wife were arguing. I had left and was speeding in my truck. And honestly, when the officer pulled me over, it should have. I think it probably should have been like what is that, endangerment or something like that. But he did the contributing. The DA threw that out, and I went with I pled guilty to reckless driving or reckless operation.
And did you plead guilty to the current charge that we're talking about?
I did.
Okay, it was a reduced charge, right? Plea bargain?
Well, yeah, it was. Yes, sir. It was a plea.
Okay.
I don't really, I didn't fight it too long because I mean, there really was no point. I really don't know what the other charge was. My lawyer came to me and said, this is what they're offering. And just to save any, you know,
Okay,
anguish or anything, I took that plea.
all right, I think we're prepared to vote, Mr. Tillis.
Mr. Ferguson, I see the remorsefulness in you. You've admitted to what you've done and you've served 18 years of a 20-year sentence. My vote today is going to be to grant parole. To grant.
Ms. Stapleton?
My vote is gonna be denied. You got a plea bargain and the child was 15 to your 30 years of age, so age difference.
Okay, I'm sorry to tell you this, but your parole has been denied because you needed unanimous. Keep doing what you're doing. You gave a good interview. Kind of unusual circumstances, but I believe that in 2 years you're gonna get out anyway. I think we need to go ahead and just suck it up and do it for 2 years. So
Yes, sir.
anyway, as of 10:22 this morning, your parole has been denied in the hearing.
Oh, Sheriff Prater,
I
what
know
do
I
you
had that
mean good
unanimous.
interview? Did you hear what I heard? I mean, and then Tillis says to Grant, he's literally talking to his victim and negotiating having the victim marry him. What? I mean, we heard the same thing. Marry him. She's what? I mean, this is insane. It's like, how do you not just like say, just because of that, you clearly haven't learned anything from your sex programs? It's just crazy. I'm like, wow. And I love the sheriff. That's just weird to say that. A good interview. Did you realize what what do you mean? Oh my God. You think about what this means. It means the mom should be locked up too, probably. I get that it's like, 18 years later or something, and she's an adult now, but there's nothing healthy about that. This just messes everything up. There's like some really messed up. Can you even imagine still having your relationship where you would have dialogue with the monster that did this to your child? Just take a step back and think about that. Think about how insane this is. Why is this thing not just a speck on the wall, just a memory, just something that you don't care to ever? But no, not only that, but you're actually talking with them and wondering whether you should get a marriage. What? I think I'm gonna grant. Unbelievable. Oh man, remember this was the same day. We're going through hearings all from the same day. So facts, on July 25th, 2007, 31-year-old defendant did this to the 15-year-old daughter of his girlfriend. What did he say? Oh, things got out of hand. We had an affair. The defendant placed his hand on her fingers in the area of the victim and used his hand in such a manner to arouse or grant the desire for himself or the victim. This act was witnessed by a friend of the victim who was approximately her same age. The defendant was charged with bill of information, which one count of molestation of juvenile. On March 24, 2008, the defendant entered a plea of guilty as charged to one count with the understanding that he would be sentenced under the provisions, blah, 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 which whoever commits crime, molestation of a juvenile when the victim is 13 or older but is not yet attained the age of 17, and when the offender has control or supervision of a juvenile, shall be fined no more than $10,000 or imprisoned with or without hard labor for no less than 5 years, no more than 20, or both. In exchange for the guilty plea, the state agreed to dismiss charges pending against the defendant, so he had more charges pending. These offenses came to light after KS had made a written statement during a therapy session. Thereafter, a physical examination of the victim by medical personnel showed that intercourse had occurred. The victims and washings and bedspread were submitted to the crime lab and revealed the presence of the defendant's preborn children. The defendants appeared before the court of the sentence on June 17, 2008. The court imposed the maximum sentence upon the defendant of 20 years. Go judge. On June 23, 2008, the defendant filed a motion to reconsider the sentence. He must have been shocked. He was probably told you'll get the minimum, you'll get 5 years. The defendant urges that the sentence imposed is cruel and unusual, excessive, in violation of the Constitution of the United States of Louisiana. The defendant, you're screwed when that's what you have to argue. And meanwhile, you literally agreed to the legislation that you could get a maximum of 20 years. He also claims that the trial court failed to articulate sufficient justification for imposition of the maximum sentence of 20 years. I mean, I don't blame him for thinking he might get less. We see people all the time get less for those charges. We see people all the time get the minimum. So it must have come, he must have been shocked. Discussion. At sentencing hearing, the state offered the victim impact statements from the victim and her parents. The mother stated that the defendant betrayed her trust in him and her daughter's trust by molesting her and SAing her and narcoticing her. The victim's father said, I'm doing a screen share if you're listening by ears, I'm using other words. The victim's father said that the defendant utilized his position as a trusted parental figure in my daughter's home, and that because of the defendant, the victim would now battle trust and self-esteem issues for the rest of her life. He said that the offense had also affected the victim's younger brother, with whom the defendant had shared a position of trust. After reviewing a pre-sentence investigation, and the trial court noted that the defendant was first felony offender whose criminal history consisted mostly of traffic violations. The court said that the victim was placed in a situation, I wonder, by the way, if his contributing to the delinquency of a juvenile, if he was being honest, that seemed quite weird charge for what he got. Under authority of the defendant in this case, the offender used his position of statute and household facility to commit these crimes. The court determined that the offense resulted in and will result in significant permanent injury and significant economic loss to the victims because these people will never fully recover. The trial court adequately articulated the reason for the sentence imposed. Further, we find the sentence is not excessive. The defendant took advantage. You would think it'd be illegal that he communicated with her. Really, I can't imagine that it'd be legal, no matter how the communication was facilitated. Unless, of course, through the one way could have been done is through the courts for a victim, or an arrangement. But I don't think that he seemed like it was through a tablet or something. The defendant took advantage of his supervisory role over the victim committing his offense. The defendant pled guilty to the molestation charge, but the evidence also indicated that other charges were dismissed, which involved actual intercourse. In both instances, the victim's was impaired. We also find that the trial court did not err in imposing the maximum fine. The court noted that the victim of this type of crime suffers significant economic loss as a result of psychological injury. The defendant raised arguments, blah, 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 blah. So the defendant argues bias. The defendant argues the trial court was biased by violating the defendant's, we'll do another hearing after this, by the way, constitutional right and fair proceeding an individualized sentence. Prior to the sentence, the trial court made the following statement. The court is, I'm intimately aware of the consequences of my sexual molestation. I have a very close member of my family that was a victim, and I know all about the effects. According to the defendant, the trial court was unduly influenced by the self-professed familial experience with the crime of molestation Defendant contends that these circumstances denied him the fair, impartial proceedings. What is it? Who said that? The court said. Oh, the court said that. Okay, that's an interesting argument. So generally, a party desiring the recusal, a trial judge is required to file a written motion, therefore signing the ground for recusal. The motion is to be filed prior to the commencement of trial unless the party discovers the facts constituting. It is interesting, right, that this judge had the personal experience and then gave the strongest sentence. The proposition, because the member of the judge's family was the victim of a certain crime, the judge could never impartially preside over any proceedings involving the commission of this crime. Look, I mean, this is an interesting argument. But they just simply say, based upon the record before us, we do not find that the trial judge's comments exhibit bias or prejudice. Conclusion, for these reasons above, we affirm the sentence. There you have it. Again, another person who really just seems to not get it. And Tillis wanted to grant him. So crazy. I don't get it. As soon as like Tillis is starting to warm up to me, I think he's doing better. He does something like this, which just blows my mind. I mean, the judge wanted to say that the sheriff wanted to say that he had a good hearing. He still said deny, but Tillis is a grant. Craziness. Okay. Let's go back to Lady Holly's crazy facts of the day for this particular case. And it's still in the Proverbs theme. Absence makes the heart grow fonder. Meaning, being away from someone or something for a period of time makes you appreciate that person or thing more when you see them or it again. Example, I used to hate going to my aunt's house. Now that I kind of miss it, absence makes her heart grow fonder. I say from experience is absolutely 100% not overstated, overrated, over exaggerated. It is true. I think our minds just work that way. We tend to forget all the negative aspects and only can remember the positives. And absence, I think, definitely makes the heart grow fonder. At least it does for me. And with that, let's jump into the next area.
Okay, there you are. All right. Are you unmuted? Can you talk to us?
Yes, I can hear you.
Okay. All right. Tell me what your name is and your DOC number.
Jim Castaneda. My DOC is 751598.
Okay. And you are in Union Parish Detention Center. And would the staff there, is there a staff member in there with you?
Yes.
Would they introduce themselves, please?
It's Latasha Archie.
Okay. All right. Well, my name is Steve Prater, and we're at the Department of Corrections headquarters in Baton Rouge. To my left is Chuck Tillis. To my right is Carolyn Stapleton. We'll be hearing your case this morning. The first thing we're going to do is hear from you and tell us why you're there, what you did. Tell us what you've done since you've been there to have earned a chance at parole. And just tell us what's on your heart. Then we're going to ask the facility there to tell us what kind of fellow you've been. And then we're going to go into some, talk to Miss Theodora Juarez, your mother, who's on Zoom, and hear what she got to say. Then I'll ask you some questions, followed by my board members and we'll vote. So as of right now, it's time for you to tell us what's on your mind and try to convince us that you're worthy of being paroled early from your sentence.
Yes, sir. Thank you. I've been here in Union Parish for 4 months now. I got transferred from Bossier about 4 months ago, and I've been a trustee the whole time. I'm in here for indecent behavior with juvenile. And at the beginning of my sentence, I ended up doing the sex offender program. That took a year. And I also did the SHI program in Bossier. I completed both of them. I submitted certificates when I submitted my parole package.
Okay.
Truth is, I've tried to be as good as a person as I can be. I used to be in the military before I got arrested, and I made a lot of mistakes. and that ended me being in here. And I've learned from them. I can tell you that from maybe perhaps a selfish perspective, there's nothing that would make me want to do any crimes, because I do not want to come back here. This has been a deterrent, because I was used to a certain type of lifestyle, and this is not it. This is not a place that I would like to be. I know that, and on top of that, I know I did wrong. I feel very remorseful. I was able to apologize through CPS a few years ago, and I was glad I was able to do that. And I've noticed that one of the biggest things I've learned is that your actions does have consequences, and this is one of the consequences that I've had to deal with now for over 7 years. I've lost a lot of things that were precious to me, and I've had to deal with that because, like I said, those are the consequences that come with people's actions, especially my actions. I lost my father about 4 months ago, and that was a big blow on me. So, truth is the matter is, I've been a trustee pretty much the whole time that I've been incarcerated at Bossier and at here. I used to be a cook in Bossier, and I went through a bunch of other different positions, the same here. And at the end of the day, I can tell you that the way I think about it now is, if I do get granted parole, it'll be a mercy. I know that at the end of the day, society dictated that I need to do my full time. And if that is the case, then so be it. And if you guys do permit me to leave here early, I can promise you that I will do anything and everything in my power to become an asset to society instead of being a burden on it.
Okay, all right. Thank you. Appreciate that. And would somebody from Union Parish, well, of course, I know all you have is 4 months experience with him. How has he been 4 months?
He's been doing good. Like I said, he's a good worker. I never seen him got in any trouble, as far as I know. He's a good cook. He worked in the kitchen, but as far as that, he's been doing good.
Okay, thank you. Appreciate that. Well, let's move on to the mom, Miss Juarez, if I'm saying that right, and I'm probably not. But it's your turn to talk about your son, please, ma'am, and introduce yourself.
My name is Theodora, and I am Jim's mom's. Part of my accent, because English is my second language. But I know Jim has learned his lesson. I love him very much, and I think he learned a lot. So I know he's going to be a better citizen, a better man, a better son. Even that, I love him very much because he's been good to me all the time. And it's so sad that his dad passed away. Being so sad because he didn't hug his son again, that he was his only wish before die. But still, I am here waiting for him and be with him. I know he learned his lesson. It was very hard for him and for me, but he has only me and I have only him in this world. So,
Okay. All right. Well, thank you, ma'am. We appreciate that, those comments. Take them into consideration. Okay, Mr. Castaneda, your case has been assigned to me, so I get to ask the questions. I don't have a lot. How long have you served in prison? How long have you been in prison?
7 years and 4 months, sir.
And what was your sentence?
9.
Okay, and so you're gonna be getting out 27 anyway, correct? Is that right?
It would be March of 2027, yes.
Okay, so you're gonna be getting out then anyway. The thing I didn't hear, and of course, we kind of glossed over, led to indecent behavior with a juvenile. It was multiple juveniles, and it was as horrible sex offenses with little kids that you're related to that I've ever read or heard. I've been in this business a long time. You did some terrible things. You know that?
Yes, sir, I do.
And I didn't hear any remorse from about the victims. about how you've ruined their lives. This isn't, as your mom said, teaching you a lesson. I mean, that's like when you steal something from 7-Eleven and your dad takes you back and says you gotta admit you stole it. That's teaching you a lesson. This is ruining other people's lives and serious stuff. So I don't know that 9 years is enough to teach us a lesson about that, but that's what bothers me. But anyway, I don't have any other questions. Mr. Coach.
Yeah, I just would like to say something, having been a victim's advocate for many years. I know this, like Chilla said, Mr. Prater said, I agree with him, the crimes were heinous and horrible. The children are in foster care. They're in foster care. I do know this, when somebody is a victim of any type of crime, as long as the person is locked up, they sleep much more easily. But the minute they find out that person is fixing to get out, their whole world comes crashing down on them. So 9 years to me is just, doesn't reflect what you did to those children, but it's the very least you can serve. And you can tell what my vote's gonna be.
Okay, I think it's time to vote. My vote is to deny. I don't think you've been in jail long enough. I appreciate your attitude and appreciate the interview. I think it was lacking some victim remorse, to be honest, but my vote is to deny. Mr. Tillett?
My vote's to deny.
My vote is also to deny. There's opposition by the judge, and I agree completely with Mr. Prater.
Okay, the time is 10:05. I'm sorry to tell you, but your parole has been denied. It's more than the end of the day.
Okay, and a couple more mic drops by the sheriff and Miss Stapleton, but to think that he would use the words that these are one of the worst cases that he's read about. While we don't have context, we don't have information on the case. What Lady Holly was able to find is really that he was, it was 2 girls under the age of 13, multiple times over several years. And the idea that they both ended up at Child Protective Services makes one think that he was probably also a fatherly figure for them, if not. There's so much more to this story. But under 13, I'm guessing sisters, for multiple years, and he gets a light sentence. And this just goes to show if there's anything that we need that we can get away with this. You know, they all had the same story, the same lack of empathy, the same lack of remorse, the same lack of insight, the same inability to even fake saying the right thing at their parole hearing. They all check those boxes. They're all the same. But they, I believe, were also all fatherly figures, all in a place of trust, all probably had dated someone to gain access to the right. They're all of this is the same. The only difference, though, is that in this case, the pathetic, weak DA and judge didn't even give the 20-year sentence a laudable, but just gave a 9.5-year sentence, which is absolute madness. They think that he was only arrested in 2018, up for parole in 2025, and getting out anyways in a couple years is sick. And what's different about him than maybe the other two is that he looks like a nice guy. I bet he cleans up real nice out of that orange. He'll be able to find more victims like this. His mother will probably introduce him to nice young ladies with children. Nice young ladies for her boy who learned his lesson. Learned your lesson. I love that he said that. Yeah, you steal from the 7-Eleven, the dad takes you back. That's learning your lesson. Forgetting your umbrella when it's raining, that's learning your lesson, right? Forgetting to put a seatbelt on, getting a ticket, that's learning your lesson. But doing this, it's calculated, it's planned. You're a wolf in the hen house. You find your prey. They have the little ones that you like. You embed your hooks, and then you go at it. And you just happen to gotten caught this time. But the DA doesn't show up. They they agree on some insane plea deal. Why? How? I mean, think about multiple years. The kids are now in living with other families in the system because of what, like the it's carnage what you've caused, absolute carnage. It's generational. And you sit here and you hear what he has to say, and it's like, what? But I always fall back on this system that doesn't do enough to protect our children from this monster. He will get back released, and if you think for a second that he won't go like a moth to the flame, what drives him, what totally, it is his obsession. He will stop at nothing. He's only going to get better at selecting his prey. He's only going to get more vicious on making sure he is not caught again. This is my opinion. But at least we didn't have to sit through and listen to a static 990 low risk assessment. At least Louisiana stopped doing that. I'm going to stop for the day with these hearings, but as I said, like Lady Holly's, this is we did these three. This one, maybe you haven't seen it yet. I haven't published it yet for you today, but it's waiting my results to publish it. I'm just going to highlight this. Whoops, 8, 24, 25. This is what we do to keep track. We got all these other hearings that I need to share with you. Look how long these spreadsheets go, all the way up. This is just 1 quarter in Louisiana of hearings. Anything that's not highlighted green, I gotta get to for y'all. So there's a lot. I'm falling behind, but it's hard. The algorithm. I have not been sharing it. Yes, I do that all the time. I don't share it. This is what I was showing with you. All these lists and what we just covered here. But it's hard. The algorithm has not been friendly. And it's always a lot more rewarding when the algorithm is more friendly, but when it hides these hearings from the communities, I have to be frank, it is harder to do it. It is harder to do it because fewer people are seeing it, and that's frustrating. But I don't know what we can do to fix the algorithm. I really don't know. Anyways, enough of that. Did we go? We didn't go through the final fact of the day here. Wisconsin, the birthplace of ice cream sundae. Few things are more American than the ice cream sundae, but would you guess that it was created with the state known for its cheeseheads? In 1881, the town of Two Rivers, a man walked into a soda shop and asked the proprietor to top his ice cream with chocolate syrup, something only used in ice cream sodas, and dessert history was made. 1881. Walked into the soda shop and said, "Can you top my ice cream with chocolate syrup?" Interesting. I mean, it just takes a genius every once in a while. When was the last time you had an ice cream sundae? I can't remember the last time I had it. I'm not a sweets person. I don't have a sweet tooth. When I do have ice cream, it will be vanilla, and I'll usually just be a few spoonfuls. I'll hit the spot, and then I'll stop. I won't do the whole thing. It's so hard. Try to lose weight, and it's psychologically, it's like, why would I Like I just did like, walked around the block for 4 miles, and now all of that will be gone if I eat this. So that's a bit tough to do. But anyways, with that, I'll let you go.
How old were you at the time you did this to this child? She was 8, and how old were you?
40, 39.
Okay. She was 8 years old. The DA goes on to say is that at this point now, you are only 56 years old and will certainly reoffend.
No, ma'am.
Well, I can tell you this, statistics show you will, because nobody can do that in the beginning unless they're like little children.